So I want you to look them up, please. I'm sending you my slide. Note the exceptions, because I could just pick one of them and throw you in the exam, or I could pick two of them. Note the exceptions. Loans to directors. Is a company allowed to make loans to directors? If not, if yes, are there exceptions? Please look at 296. Under what instances? Payment for loss of office 298, 299, also 300. Please note them. Payment for loss of office and all that. But I want us to jump to duties. And see what we can do so that we can wrap up this class.
Excuse me.
Yes, please.
This, you said that it is not compulsory for directors to be paid.
No, it's not.
So that is why you have fraud. Because you now see them. I've worked in some committees and will determine what we are going to be paid, which is even better than not being paid. But if the board, if the company decides that they should pay us, and
actually, what happens in practice is that every company, particularly for public companies, are required to have what we call a remunerations committee. You know, companies operate, board of directors usually operate through committees. And some of these committees could include the recruitment committee. You could have the accounts of financial committee, and you could have a remuneration committee. So the remuneration committee will determine and table before the board of before the members in general meeting a proposal for remuneration. So in practice, non-executive directors could still be given allowances, you know, but they are not paid salary because they are not working. And KAMA even provides, I can't get the section in my head now, that any director who benefits undeservedly must return that money back again to the company. Let's talk about directors' duties quickly. Again, I told us that directors are trustees of the company, particularly with respect to the assets, property, income of the company. And as trustees, as you know, they are required to observe the utmost good faith in their dealings with the company at all times. So you want to see that in section 305. They have fiduciary obligations with respect to and the company, and this obligation still persists even when a director. This obligation persists even when a director is an agent for a particular shareholder. So LNG has appointed, and Shell has appointed me to be its director on the board of LNG. So definitely I will owe allegiance to Shell that has sent me to that board. But that notwithstanding, my obligation or my duties to the company to observe the utmost good faith still persists. That's what we are trying to say. Secondly, this duty still persists even if I'm a multiple director. So we could have persons who are multiple directors, or they hold multiple directorships. Maybe I use that. That's a better word. So I'm a director in company A, B, C, D, and E, and F. The law says no problem, you can do that. But if you are going to be director of 5 companies, you have to know that you have a fiduciary obligation to the 5 of them. And so you cannot use information that you have obtained as a fiduciary from company A and use it for company B or company C. So you are in a very dicey position. Again,
even if they are not co-competitors.
Even if they are competitors. Even if they are not, even if they are, you cannot use the information you have obtained here for this one. Of course, if you make disclosure to the members and they allow you, why not? But the main thing about a fiduciary is that he must not act in secret, and he must not put himself in a position where his own personal interest will conflict with the interest of the entity that he manages. Is it not so? Is it not so? Yeah, so So they are to act at all times in what they believe. A director is to act at all times in what he believes is to be the interest of the company as a whole, so as to preserve its assets, further its business, and promote the purposes for which it was formed. And it should act in such manner as a faithful, diligent, careful, and ordinarily skillful director would act in the circumstance. Okay, so the good faith, determining good faith is a very subjective thing. It's very subjective, but the court will look at the circumstance of each case and conclude if a director has breached. And you know, when we're talking about good faith, for the most part, we use the reasonable. When we're talking about subjective things, we use the reasonable man test. Is it also? What will a reasonable person have done in the circumstance? So please note these cases. Again, a director under that section 305 must not fetter his right to vote. He must not fetter his right to vote. He must not contract with another party that he will exercise his voting rights for a collateral purpose. So see 305 sub 5, a director shall exercise his powers for the purpose for which is specified and shall not do so for a collateral purpose. And the power if exercised for the right purpose does not constitute a breach of duty if it incidentally affects a member adversely. So that is another very crucial thing you need to know. So as long as he is pursuing the interests of the company, it may affect the shareholder in his personal capacity. Notwithstanding the fact that you are a shareholder of this company, if what I'm pursuing is the benefit of the company, my decisions as a director may affect you adversely. So that does not mean it may affect your own business interests. So you have a company, Asufi has a company, Mr. Asufi that is involved in a coconut plantation. It's a shareholder in this company, and I'm a director. And I feel that for this company to survive, we need to go into coconut plantation. I will now be his competitor. That is not our business. Provided I'm pursuing the benefit of this company, that it affects him adversely. I think that makes sense. Let's move on. Okay, so I say he must not fetter his right to vote. Please look at section 305 sub 6. He must not fetter his discretion to vote in a particular way. He should operate with independence and integrity, and it is wrong for directors to contract as to the advice they are to give to the shareholders in a future matter to be decided before the shareholders even exercise their discretion. So it's wrong to contract and say when the company meets and when the board of directors meet in April, this is how I will advise. So I'm contracting in advance with Kubo. You know that when we meet, I will advise the board of directors to buy your property. That is breaching my fiduciary obligations. Okay.
What if it is in good faith?
Yes, if it is in good faith, you see there in my slide. If it is in good faith, again, he must disclose. He must disclose, then it will be okay. Okay, so please, I want you to just a minute. Okay, so yeah, so please also see section 306, conflict of interest. Conflict of interest. You know all these rules from your commercial law, but please see section 306. He must not put himself in a place of where his personal interest will conflict. So if he comes in contact with information, property, and all that, he cannot make secret benefit. That is the whole idea. You cannot make secret benefit. You have to disclose. You have to bring it, and it all starts. You know, corruption starts little by little. That is why we have to fight it. If you don't fight it, before you know, you are corrupt. Many people you see that are corrupt, they did not start. I'm legal advisor to my estate, and recently we had some issues. And I was required to engage a lawyer to handle those issues. And the lawyer I got was my roommate in law school, very close. And after they paid him, he wanted to appreciate me. It's those appreciations that bring corruption. So I told him, please give the money to your children. Buy balloon for them with the money. But if I was to get that money then it will be my duty to bring it to the rest of the ESCOs and say, yeah, please, my colleague that I used to pursue this matter for the estate, out of his gratitude, he has given me this. Him, they say, keep it, then it's okay. And you know that is a hard thing to do. You know, so most times you just feel it doesn't matter, and before you know, you start expecting. And so any matter you bring to this person, you expect him to give you something. And if he does not, kick back. And if he does not bring it, you hold a grudge against him. And so the next matter that comes, you look for another lawyer, and before you know, you are sunk. So I remember I was doing a matter in those days when I was going to court. I learned this from one lady. So I wanted to just, you know, when you go to court, you always tip all the registrars, the court clerks. I wanted to tip her. She had already done everything. So, madam, just hold this one. She said, no. I said, I'm just giving you now. She said, if I collect, I will start getting used to it. I don't want to start. And so, okay. So section 306 is saying, don't use information, don't use property, and that obligation still persists even when you are no longer a director of the company. Even when you have left the services of the company, you cannot use information that you obtained in your position as a fiduciary against the interest of the company or for your personal interest. And of course, you know the duty to account is always there, so you can always be called upon to account. And any benefit you make in that capacity, you'll be holding it on trust. Is it not so? Is it not so? Yeah, you'll be holding it on trust for the company. Any questions? Okay, so let's rush quickly. Let's rush quickly because we just need to wrap up this topic now. I talked about multiple directorship. A director of a public company now under section 307 cannot be a director of more than 5 public companies. In the past, there was no limit, but now it can be a director of more than 5 public companies. See section 307. But for the private company, there's no such restriction. And does the director have? Do directors have a duty to disclose their misconduct? See the case of Bell versus Lever Brothers Limited. Under common law, directors are under no such duty to disclose their misconduct. But see the case of Bell versus Lever Brothers Limited. You must have come across this case in year 2, contract law. You remember? Yeah. Excellent. So please look it up. And then let's talk briefly about the common law duty of care and skill. Common law duty of care and skill. So we have been talking about the fiduciary duty. Now there's a common law duty of care and skill. In the past, directors were not required to have capacity and skill above their standing in life. So if you brought a mechanic to manage a financial services firm, the duty, the standard of knowledge he ought to have had would have been that of an ordinary mechanic. And so if you are suing that director for being negligent in the management of a financial services firm, the standard of duty that will be required of him will be, would another mechanic have understood these documents? No. Or would a farmer have understood this complex financial document? No, a farmer will not have understood it. Then this man also should go free. Number 2, directors were not required to even attend meetings. They were not required to attend meetings. So once you were appointed to the board, you were not required to attend meetings. And there's a case, I will give you my slide, where a young man was appointed as a director when he was six months old. He never attended any meeting until he was about maybe 19 or 20. And when there were issues with the company, an action was brought against him, and it was held that he had no obligation or duty to attend meetings. Are you with me so far? Are you with me so far? I hope I'm not talking to myself. I have a lot of things to do. So much. So I'm not here to tickle you. Respond in Jesus' name. We must finish this thing today so that when we meet on Wednesday, we'll talk about something else. But what Kama has now done is to raise the bar. To raise the bar with respect to duties of directors by providing that standard of care and duty, standard of duty and care will require of you is that of a director managing that particular business. So if you are a lawyer going to manage a financial services firm and there's an action brought against you for maybe negligence, the standard of care and skill and capacity we want to see to use to determine if what you did was right or wrong would an ICANN certified financial expert have done this. Not will a legal practitioner have done it, because a legal practitioner may not be expected to understand so much of accounts and all and financials. So that is what I want you to note. Secondly, directors are now mandated to attend meetings, and if you don't attend the meeting of the company and the board takes a decision, it will be binding on you. So if the board takes a wrong course of action, you will bear liability with them, except your absence from the board was justified. So please look up section 308, look up Dorchester Finance Company Limited versus Stebbing, look up Bridgedown of London, and I will send you my slide as well. So let's rush. So there are a number of provisions. What is the time? Let me see the time. How many minutes?
12.
2 o'clock.
2 o'clock, yes.
Okay, so just 10 minutes and we're done. So I will send you my slide. I would like you to go and read disclosure of direct interest. There's one thing I want you to note in CAMA: disclosures and approvals. Disclosures and approvals. And I have already pointed out a number. So one of the ways CAMA checks directors is to require that they should make regular disclosures. And another way it checks them is to require them to obtain approvals from the members. So I want you to note, at least you should be able to note 5 disclosures and 5 approvals in case I'm in a good mood and I throw it to you. Okay. Let's talk briefly about secretaries. Then we should be done. Secretary. So a secretary of the company is an officer of the company. In the past, secretaries of companies were regarded as junior, what you may call a junior staff in the firm, a clerk, a messenger, and all that. But the status of secretaries has changed, particularly from 1971, in the case of Barnett Was and Company versus South London Tramways Company. Since that time, and in Panorama Developments, Guildford Limited versus Fidelis. So that's the 1971 case. Lord Denning, particularly, his dictum reflected a new position of the secretary of a company as an officer of the company, and that is why when you go to the definition section 868, you see that an officer of the company includes director, manager, or secretary. Director, manager, or secretary. So secretaries are persons who are appointed. They are not appointed by the members. They are appointed by the board of directors. They are not appointed by the members. They are appointed by the board of directors. But for public companies, if you are going to remove the director that you have appointed as the board, you will still need to obtain the approval of the members in general meeting, or at least you need to inform them. So I want you to look up section. Please don't disturb the class. Don't make it rowdy. Sit up. Sit up. We just have 10 minutes. Give your best. Tell your neighbor, give your best.
Give your best.
Okay, so for a private company, you can appoint anybody as a secretary. And what Kamana has provided is that for a small company, you don't need a secretary. For a small company, you don't need a secretary. In the past, every company must have a secretary, and the secretary ought to be somebody who has the capacity, in the opinion of the board of directors, has the capacity to discharge the duties of the secretary. But for the public company, we still need to appoint either a lawyer, a chartered secretary, or when I mean chartered secretary, I'm a person who is a member of the Institute of Chartered Secretaries and Administrators, or a chartered accountant. So it could be somebody who belongs to the ICANN branch or the ANAN branch, as the case may be, or it could be a legal practitioner recognized and all that. Or it could also be a firm. So the secretary of a company may not be a person, but it could be a firm of lawyers, a firm of accountants, a firm of chartered secretaries, as the case may be. So look at their qualifications. Then also, is the secretary a fiduciary? Is he a fiduciary? Yes and no. Look at section 334. Look at section 334. Then look at removal of secretaries. Look at removal of secretaries. There's one case I want you to note there. Daily Times Nigeria PLC versus Akinjide. Yes, Akinjide. So please, that case is very important. I want you to note it. So removal of the secretary. Again, you have to comply with the provisions of the law. And if a person is a legal advisor and also the secretary of the company, his appointment as secretary automatically protects his appointment as legal advisor. Please look up that case. And when you want to remove him, you must comply, particularly for public companies, you must comply with the provisions of the law. You must give him notice and give him opportunity to defend himself. If the allegation against him borders on fraud or serious misconduct, and he defends himself, then the board of directors, if they are not satisfied, can go ahead to remove him, and later on notify the members in general meeting. But if the allegation is not one bordering on fraud or serious misconduct, then they can only suspend him and subsequently obtain the approval of the members in general meeting. So, ladies and gentlemen, in the light of our constrained time, we have to compress this topic. Normally, directors should have taken us at least 6 hours, at minimum 3 different meetings, but we don't have that in luxury, so we just have to compress it. So please go back again, listen to the audio. A lot of things I did not say here, I said in the audio, and some of my past videos are also on YouTube. If you have money, you can download and listen and build yourself. And so we meet again on Wednesday. It ought to be 10 o'clock, but I will see if we can meet by 9:30 to 11. Thank you very much.
So this one is going to be on YouTube.
Hopefully.